Hello and welcome. Welcome to our Farm and Ranch Friday live podcast. Very excited to have you. I am your host, Lindsey Hollin. I am one of the 10 managing brokers at eXp Realty in the state of Texas. I'm also a farm and ranch broker, been in the business since 2015, but been in the farm and ranch community my whole life. So I'm very excited to have y'all listening from all over. This is an open and public podcast for not only EXP agents, but farm and ranch agents, agents that are interested in getting into this field, as well as the general public who may have interest in buying and selling land. Without further ado, we always have special guests, but I love my attorneys. And I am over the moon that we were able to have and host Mr. Russell Johnson. He is an attorney at law specializing in our fabulous water rights, as we know in Texas, as well as in other states. Water is gold. So we're very excited to welcome him here today. Man, I was reading just his history and background, the accolades, and some of the cases that he has been a part of. Really are historic and amazing here in Texas. So I'm not going to rave a little bit too much. We were introduced to Russ by one of our amazing EXP Farm and Ranch agents, Stacy Bray. So Stacy, I'm going to let you take it away so you can tell them a little bit more about your background and how you were able to connect with Russ.
Well, my background, I have a lot of water background starting at basically as I was born. We were on the water constantly. I've always gravitated towards water. And one year I was at a event up at the McDonald Observatory. It's the UT Observatory, and that's up in Fort Davis. And my father-in-law, who is a real estate attorney, introduced me to Russ Johnson and said, hey, he's a professor at Texas State University, which is where I was going at the time. And they talked me into taking one of Russ's classes, which was water policy. So I thoroughly enjoyed his class and love talking to him when I get that opportunity. So Russ is great in telling us what we need to know on water policy, and he has been instrumental on legislation. Even you will all remember, or know Edwards Aquifer. He was instrumental in creating Edwards Aquifer with San Antonio. So he has a whole big just so much history and so many things that he's been involved in. If you want a little bit more information, because I really want Russ to tell you more of what we need to know about water, and he is so good about doing that. My class was amazing. So I don't want to focus too much on your history, Russ, because I think it speaks for itself. And if anybody goes into your website, they'll be able to find out a little bit more about you. So,
and I did want to let you know, Stacy and Russ, I put to our audience in our chat, in our comments box on our platforms, we have posted our guest speakers information, as well as the website the overview of the firm that he works with, as well as news publications. And his experience. So click on that link. And also Russ's contact information is there as well. If there's something that comes up in this podcast, whether you are one of our farm and ranch agents, brokers, or general public, Russ is available to all. So like I said, I'm super excited that we have him, because this is a major topic of what we do in our profession, and having you as a resource. We are so blessed. I feel like in Texas, we have so many great leaders in this industry that help all of us have the end game of protecting our land, helping our clients learn more about the land, and to keep it going for future generations.
Well, thank you both for that introduction. And yes, it's true. I am a lawyer. Probably I laugh with my dentist friends that we're probably practicing in two of the least desirable for the client or patient practices. Nobody hates to go see their other consultants, but lawyers and dentists usually involve pain. So that said, let me give you a brief background. It's true, I'm old. I've been practicing for quite some time. I got into water by accident. I was a full-on litigator, usually environmental litigation, in the 80s until the Edwards Aquifer wars broke out in the early 90s. It's a long story, but I'll shorten it by saying San Antonio's, at the time, sole water supply was the Edwards Aquifer, which was also the source of Comal and San Marcos Springs and New Braunfels, which supplied a substantial part of the base flow of the Guadalupe River. And under the law at the time, the rule of capture, San Antonio had the absolute right to produce as much water as it needed without regard to the consequences. So we were in San Antonio threatening the continuous spring flow at Comal and San Marcos Springs. That resulted in litigation by the Guadalupe interests under the Endangered Species Act, because there's some endangered species in those two springs, to limit our groundwater supply. And in the federal lawsuit, Judge Lucius Bunton, now deceased, ruled in favor of the plaintiffs and literally imposed draconian limits on the amount of groundwater that San Antonio could produce, which resulted in the state passing the Edwards Aquifer Authority Act, which for the very first time literally authorized regulation of groundwater use within the Edwards Aquifer and limited that use to protect those endangered species. I like to say I became a water lawyer because, as the city of San Antonio reminds me regularly, I lost that case. As a result, San Antonio's water supply was constrained, and San Antonio needed to develop additional water to meet its not only existing but future demand. And that resulted in an outreach to projects which obviously involved all the regulatory overlay that would be associated with developing that water. So since the 90s, my practice has been almost exclusively in the water arena, mostly, thankfully, in what I call the transactional world as opposed to the litigation world. Although, sadly, as the old saying goes, water's for fighting. There is often litigation that involves the water issue. So let me just jump right in and say, I'm speaking to folks that already know that water is an important component of the ownership interest of real estate in Texas. Both surface and groundwater are extremely relevant to the value of real property. And it's important to kind of understand the framework within which those two types of water operate, because surface water in Texas is all the waters in what I call streams, creeks, channels, rivers, anything that is channelized ultimately will be deemed to be surface water. And surface water is owned by the state of Texas, not by the landowner. It's subject to use by the landowner under, and I'll explain in a little more detail, either exemptions from the regulatory programs that are meant to administer the use of surface water, or by permit. So, and that permit is issued by the TCEQ, Texas Commission on Environmental Quality. So, and groundwater, of course, is owned in fee simple by the landowner. It's as we like to say, and you probably do too, it's part of the bundle of sticks that you acquire when you acquire real property. The obvious component of that is you intend to potentially use that groundwater, and we're going to talk about limitations, if any, and exemptions from regulation in the groundwater arena as well. So let me kind of start with surface water. I've already told you what it is, but what is important is that if you own a piece of land, you have the right to use surface water that you acquire or divert on that land for domestic, livestock, or wildlife purposes without requiring a permit from the state of Texas. So if you live on a creek, you have the right to withdraw water or impound water from that creek and use it. And when I say impound that creek, there's a concept of law that you have the right to do that, but you can't do it to the exclusion of downstream flow that would otherwise be available to your downstream neighbors. So I don't want to leave you with the impression that you can build a giant dam on your creek and property and prevent the downstream flow of that water to downstream users. So having said that there's this exemption, I want to emphasize this is really important in the farm and ranch community, because I haven't seen a ranch yet that doesn't have a tank of some type somewhere, and maybe plenty of them. And it's important to know that you can maintain and operate a tank on your property, capturing surface water, and you can capture a ton of surface water for those uses, but exclusively for those uses. Under Texas law, you can impound up to 200 acre-feet of surface water for use for those purposes. And one of the weird things about water is that the unit of measure that is often used is an acre-foot. I just mentioned it. That's a lot of water. That's 12 inches of water covering an acre of land, which translates to a little over 326,000 gallons per acre. So just keep that in mind, that you have the right to impound and use for those purposes without a permit. And I say without a permit to use the water. There are other permits that you may need in order to do that. I don't want to leave the impression that you can just build a dam and impound up to 200 acre-feet. There are typically regulations involving stormwater protection, permitting by your county or your local jurisdiction, et cetera. So all use other than domestic livestock and wildlife use of surface water requires a permit from the state of Texas issued by the TCEQ. And those permits basically outline what you are authorized to do and have what I call cardinal conditions. And I'll kind of run through them. Those are point of diversion, diversion rate, quantity, purpose of use, and place of use. And those are important in the context of the market, because a surface water permit with those 5 conditions, if amended or intended to be used for a different purpose, has to go through the amendment process at the TCEQ to make that happen. So if you own a water right that's for irrigation purposes for the farm, and the intent of the buyer or the goal of the seller to entice a different use of that water based upon that water right, understand that it's not automatic that you are able to convert that agricultural use, say, to a commercial or industrial use. The other interesting thing about surface water rights is that they all have birthdays. They're called the priority date of the water right. because water rights, surface water rights in Texas are managed based upon priority dates. So it's one of the few instances where older is better. In surface water rights, if to the extent there is a need to restrict surface water use to protect water rights, that's based upon the priority of the water right that is imperiled by upstream use.
Ain't that the truth in real life? Older is better.
Well, I'm not so sure about that.
I don't know. I have a 1930s Craftsman home, and I'm telling you, I don't think you could tear that puppy down. We went through the ice storm, no problem.
There you go.
Man, I gotta tell you something real funny. Because I can see the live feed of the chats coming from our viewers. And one of our agents, her name is Rocky, she said, I believe I watched an old Western with John Wayne where he busted up a water dam. I was just cracking up some of the comments that we have from our agents. I want to give a shout out real quick and just remind y'all, please put your comments in the chat. I can see them publicly. And then I also was going to let y'all know, welcome. I see that we have agents hailing from Galveston. Rocky, I cannot pronounce where you're from. Is it Mount Bellevue? It's obviously you gotta love Texas spelling out there. I got Bernie from Bernie's out in Stephenville, Texas. So super excited to have y'all from all over. Coppers Cove, man, just dropping where you're from in the chat. Very excited. Hey, Joe, I have some team members out there listening. That's exciting. I love to see who actually sits and wants to hear from me and my guests. So very excited about all their feedback. So don't forget to jot your questions in the chat. Russ, I wanted to ask you a few questions if you don't mind.
Fire away.
Okay, so you mentioned the TCEQ. Can you explain what the TCEQ is and why it's important for our farm and ranch brokers and agents to know about that resource?
Good question. And the TCEQ, the simplest answer is the Environmental Regulatory Agency of the state of Texas. They have very broad jurisdiction in all matters, literally all matters involving the environment, from solid waste to water to air, you name it. And it's an administrative agency of the state of Texas. The TCEQ commissioners are appointed by the governor, and they basically administer, at least as relevant to the water question, the surface water rights of the state of Texas that are permitted. And that's the agency that you must apply to in order to obtain permission to use surface water anew. So that's kind of a short summary of the TCEQ. Is that sufficient, Lindsey? You're muted, I think.
Sorry. Thank you for reminding me. I'm always terrible with my microphone. I did want to let everyone know I dropped a link in the open public chat to the TCEQ. That way you can take a look at it. I know that I use the TCEQ quite a bit to research water wells. I know some individuals use third-party sites like MapRight, for example, to try to pull water well information. We don't always have a well log. More often than not, the clients don't have the well log, especially if it's a much older well. But definitely check it out and look at that resource. It is a very helpful resource, as you mentioned, as the Texas Commission on Environmental Quality.
Yeah, let me mention also that there's another state agency called the Texas Water Development Board, and it has two primary functions. Really, one is what I call the accumulation and dissemination and development of data relevant to water, both ground and surface. and they're a funding agency for water projects. So, and their website is loaded with information about surface water sources and operation and groundwater sources. So just kind of keep that in mind. And let me kind of finish up with surface water by saying, as I mentioned before, every water right has a birthday, and in the event of shortage in a water course, the priority date has real significance and importance because, and this is going to become more and more common. The majority of the surface water courses in Texas are fully appropriated. That's a fancy way of saying the water's already been, in essence, claimed. So getting a new permit is a challenge in a water course, but relevant to the priority date, if there is a shortage, the TCEQ will suspend or, in essence, require cessation of diversions by junior water rights holders upstream of a senior water right holder who has suffered an inability to obtain their water. That's happened only once in recent history. In 2011, the TCEQ issued curtailment orders in several river basins. And the importance of that is that unlike what we're used to in real life, and that is, staged reductions because of drought, if there is a call on the river and there's a decision by TCEQ that protection of a senior water right requires suspension of use by junior water rights holders, that suspension is 100%. So if you have a junior water right on a river and a senior call is made and issued by the TCEQ, your right to withdraw water is completely suspended. So I mentioned that in the context of your practice because birthdays matter. The older the water right, inevitably the more valuable it is. So let's talk about groundwater, which really I kind of made my bones in water in the groundwater arena, largely because of the Edwards Aquifer battles. But I'm sure you're aware that groundwater is part of the fee ownership of the real estate. Its ownership is established under what is commonly called the rule of capture, but legally is called the absolute ownership rule. And that absolute ownership rule is the same rule that applies to minerals. So in essence, water, like oil and gas, is a separate estate or a component of the estate of fee ownership of the land. As I mentioned, the rule of capture is a funny law. It's a law of no liability. Bottom line is that under the rule of capture, you can produce as much groundwater as you beneficially use without regard to the impact of that use on neighboring wells or landowners. That principle, of course, led to the battles over the Edwards Aquifer, and those battles led the state of Texas to decide it was time to provide for regulation of groundwater use, and they did so by empowering what are called groundwater conservation districts. And it's important to understand that groundwater conservation districts are local governments. They're simplistically mini TCEQs. So practically speaking, they're authorized by the state, once created, to manage and regulate groundwater production within their jurisdiction. And that's important because they are regulating and managing a vested property right. And, you know, I won't bore you with the details, but the big debate until the mid 2006, 2007 timeframe was whether the groundwater right was a vested property right. And that's relevant because to the extent a vested property right is taken away by the government, you have a claim for the taking of that vested property right. So if the state came in and said you can't produce your oil and gas, you could sue the state for a taking of that vested property right. The problem with water in the context of a vested property right is, unlike other property rights that you own, you can't protect it. There's no exclusive right, if you will, and you have no remedy if your neighbor uses so much water that it deprives your property of that use. So it's a rule of no liability, so to speak. What's really kind of interesting, I think, is that the Supreme Court has further said that the groundwater right, when severed, is the dominant estate. And that's true of oil and gas as well. So if you own the oil and gas under a piece of property separately from the ownership of the surface, as the dominant estate, you have the right to use the surface to extract those minerals, and you don't need anybody's permission. The same is true of groundwater. And that's particularly relevant in what we're going to talk about a little later, and that is the severance of the groundwater right by a landowner and the sale of the surface separate from that groundwater. So, you know, given that you're subject to regulation, let's talk about what these groundwater conservation districts are and what they can do. There are 101 of them at the websites that we've mentioned, Texas Water Development Board and the TCEQ website. If you drill down, you can find on those websites a map of all the currently authorized and functioning groundwater conservation districts in Texas. That ought to be your first stop when you are looking at groundwater use on a piece of property. Is it within the jurisdiction of one of these groundwater conservation districts? And just know that most of the state that is what I would call capable of accessing usable, functional quantities of groundwater are within currently the jurisdiction of a groundwater conservation district. There are 101 of them. They're governed by Chapter 36 of the Texas Water Code. They're given a great deal of power to manage. They're also given a kind of an obligation to manage and protect, which obviously comes in conflict with the, I apologize for the barking dog.
Please don't. If you knew my crazy with my Jack Russell Terriers, it's I literally have to lock them outside in jail because they're like right on top of me. Normally, my sweet Jack Russell joins me in the podcast and sits on my lap, but I am actually in El Paso, Texas, with some of our amazing West Texas agents. So no, we love pups here in the farm and ranch community. So please don't worry about it.
My apologies there. So having described to you what are groundwater conservation districts, that's particularly relevant in the real estate transaction scenario, because part of your due diligence should be examining groundwater use on the property and the extent to which that groundwater use might be subject to regulation by a groundwater conservation district, and the authorizations that the landowner has, permits, from that groundwater conservation district to make use of that groundwater. These groundwater districts can establish limits on production. They can manage to achieve their what's called desired future condition, which is what they want the aquifer to look like after 50 years. Inevitably, that means that the groundwater conservation districts are looking at a total limit on groundwater production within their jurisdiction. The planning process requires them to take that desired future condition and apply groundwater models to determine actually how much water can be produced annually and still achieve that desired future condition. And I'm babbling on about that because most groundwater conservation districts have decided that the amount of water that should be producible from their managed area is just enough more than their current demand to meet anticipated future demand within their jurisdiction. And I mentioned that in the context of the market for water because that leaves very little water for use outside that limited jurisdiction. If someone desires to move the water from where it's produced to outside the boundaries of a district. So importantly and thankfully, groundwater districts are required to exempt from the permitting process wells that are used for domestic livestock and wildlife purposes if they meet certain conditions. And those conditions generally are, and you need to check the rules of the groundwater conservation district, but the general conditions are they have to be small wells. They cannot be capable of producing more than 25,000 gallons of water per day, which translates to about 17.3 gallons per minute. Any well larger than that within the jurisdiction of a groundwater conservation district will require a permit from the district to operate it. Just be mindful of that. So don't panic if you see, wells on a piece of property. That's likely not triggering any kind of a requirement that you have a permit, but make sure that that well, and by the way, there's no limit on the number of wells. Large properties are going to have many. Each one is exempt, so it's not a collective limitation. The other limitation that's important is, at least under Chapter 36, the tract has to be at least 10 acres in size. So understand that if a tract is less than 10 acres, it could be, you could be required to obtain a permit to produce, even for domestic livestock and wildlife purposes, from that property, even though it's a small well. So keep that exemption in mind. Are you waving at me, Lindsey?
I'm raising my hand because you literally just blew my mind. Okay, so can you repeat that number again for me? So the gallons per minute for a well that doesn't require that type of permit. What is that number again?
17.3 roughly gallons per minute. 25,000 gallons per day. If the well is larger than that, and you can limit it by pump size, obviously, but if it's capable of producing more water than that, and it's within a groundwater conservation district, even if it's used for domestic livestock and wildlife purposes, it may require a permit.
Absolutely. And while we're still on this topic, we did have about 5 questions come in. So I have Kurt. He's actually hailing from our LinkedIn channel broadcast of this podcast. And he was asking, do you know what is the latest or recently found about the Maverick Basin Aquifer?
Wow.
I told you we had some advanced people in our group.
I I'm a water guy. I've been a water guy forever, and I don't even know where the Maverick Basin is. Um, so perhaps a little more definition.
Hey,
Would
Kurt, if you can hear me, if you want to reach out to Russ directly and maybe fill him in, because he also may have some associates that have more expertise in that region. Obviously, Texas is a massive state, and we have a lot going on with water. But I appreciate your question, Kurt. That's super awesome, because obviously that can affect the buying and selling of that. And that was Kurt Moody, as you can see. He's hailing in from our LinkedIn channel. And then also, I had a question. Don't really see the name. They have an abbreviation, MB. Is it possible to connect a river to a local pond?
So,
or hold on, and let me add a secondary to that, because he said, or creating a pond in the center of that river.
Well, first of all, rivers are difficult to impound. In other words, you can't build a dam on a navigable river in Texas, and virtually every one of the named rivers are deemed to be navigable rivers. So, but yes, you can divert water from that river and impound it on your property in a pond or tank for those purposes, domestic livestock and wildlife, without a permit, and you can divert a ton of water up to 200 acre feet.
Okay, so I know, I thank you for that, and you guys that have these very specific questions, I know it's kind of hard for us, and also on our side, depending on the question, the question, and then the answer, and then that answer may lead to another question to figure that out, because there's a lot of moving parts, as all of you know listening. So there isn't always a cookie cutter black and white answer in these scenarios. There's a lot of factors that lead us down to the correct response or solution to providing our clients with an improvement, a water improvement that they like. So thank you guys. Thank you, MB, for that. Also, I have a question. MB has another question for us. Is the Water Conservation District, is the county mud, or are they a co-op water properties which are privately owned? I'm not sure I understand, but I put that question in front of you.
Yeah, I'm not sure I understand it either, but groundwater conservation districts are governmental entities authorized by legislation to manage groundwater. MUDs, co-ops, water supply corporations, maybe quasi-governmental, certainly MUDs and water supply corporations. They have no regulatory jurisdiction. They're like any other user, so to speak. So they don't have any kind of superior right necessarily to manage and use either surface or groundwater, just so you know. And going back to the Maverick Basin question, one of the great things about the websites at TCQ and Texas Water Development Board is they also have maps of the major and minor aquifers of Texas. And they obviously have a map of the groundwater conservation districts of Texas. So in answer to your question, you're going to want to find the Maverick Basin on the map and then translate that into whether or not it's within the jurisdiction of a groundwater conservation district.
Awesome. I think that's all of our questions for this segment of our chat. So what direction are you taking us now, Russ?
Well, a couple of quick things. I want to mention that regulation can result in a taking of a property right. I mentioned that your groundwater right as a landowner is vested. Just be aware that the regulatory takings requirements are stout. You have to prove, in essence, you've been deprived of what I call the typically it's described as all the value of the resource. So some regulation probably doesn't constitute a regulatory taking. Absolute prohibition does constitute a regulatory taking. I want to also mention how groundwater districts regulate real quick. They allocate, typically in their rules, authorizations based upon the surface acreage owned. So you'll want to check the rules of the groundwater conservation district. Typically it's in acre feet per acre of surface owned. Some use spacing between wells as their regulatory mechanism. Others basically decide permit decisions on an ad hoc basis, which is very frustrating if you're trying to get a permit because there aren't any absolutes. It's pretty much up to the groundwater conservation district. And one other thing I'll mention, and I kind of alluded to it real quick, is that historic use, that is use that is recognized by the district as preceding the regulation, since most groundwater districts are less than 25 years old or less, is managed or regulated by groundwater districts under an authorization that allows the district to allocate to historic users their historic use without regard to the limits that might otherwise apply to new use. So for instance, if a landowner is using more than 2 acre feet per acre and the groundwater district limit is 2 acre feet per acre, and that use predates those rules, typically the district will authorize the amount of historic production. New use, not so much. So what I'd really like to kind of talk about is the water market, which obviously has some real relevance. And of course, you know that in your practice that the water circumstance of the property has a great deal of influence on the value of that property. But I'm going to try to kind of take out the water component and look at the quote market value of the water right independently of the real property, and give you some frameworks to kind of consider as you look at a piece of property. The really interesting thing about water to me is that it's a commodity. It's sold in units. And what's different about water is that virtually every other commodity in the market has a market price. If you want to know what the market price of gold is, or wheat, or corn, or bandwidth, any number of quote commodities, you can look it up in the Wall Street Journal. Water as a commodity defies the ability to establish a market value. So there's no frame of reference because there's so many variables associated with water. There's really no way to come up with a common value. But I do want to kind of help you understand what water costs and what its consequent value might be. So most of us are connected to a water system that supplies retail water to our property. Typically, the rates that are charged by the supplier are in the range of, let's just say, $3 to $5, sometimes much higher, per 1,000 gallons. You can do the math. $1 a thousand equals 326,000 gallons of water, so $326. So $4, you can do the math. Water sold at the retail level for somewhere in the neighborhood of $1,500 per acre foot. The interesting thing about water is it can be sold separately. It can be sold as a commodity. The water right can be sold. There's a big difference. If you're selling the water, you're selling it as a unit. If you're selling the water right, you're selling it as a permanent sale. So keep that in mind. It's kind of like the difference between leasing and selling. The other thing to keep in mind about the market in water, starting with surface, is that you're likely required in order to, quote, market that water to obtain an amendment from the TCEQ that authorizes what you intend to do with that amended permit. Those can trigger a contested case hearing, an administrative process before the administrative agency that can be complex. So for instance, if you intend to amend and authorize a different use or transaction in surface water on the Colorado River, you apply to the TCEQ. They give notice to all the water rights holders that might be affected in the Colorado River basin, and they have the right to protest your requested change or amendment. So moving the diversion point, for instance, changing the purpose of use or place of use can trigger this process that results in a contested case hearing. In other words, if someone protests the change, that's then sent to the equivalent of an administrative law judge who decides whether or not that amendment, that change, should be authorized and whether it might be conditioned. And that's a level of uncertainty that influences the market value of that surface water right. The same is true of a groundwater permit. Any change, if you're using groundwater to farm the property and want to change the purpose of use to industrial or commercial, that requires a permit amendment. And the same principle applies, oddly enough, that you apply for the amendment to the permit to the Groundwater Conservation District. They give notice. Typically, it's a public notice, not a specific notice, but most groundwater districts require notification to adjoining landowners and or well owners within a certain distance from the proposed well that will be subject to the amendment. And once again, that can trigger protest by allegedly affected parties, which can then tumble that request into a contested administrative hearing process, which is like a trial. The administrative process can be, and since it's like a trial, there's discovery, there's all these what I call expenses associated with that, and the uncertainty that can inevitably result in a protest. So I mention that because that constrains to some extent the value of the groundwater permit right. It's not freely transferable. There are some exceptions. The Edwards Aquifer Authority, oddly enough, is one of those, largely because the Edwards Aquifer doesn't care where you withdraw the water from. So practically speaking, Edwards Aquifer groundwater permit rights are freely transferable, with this exception. Water rights issued in Bexar, Medina, and Uvalde County can be transferred within those three counties without any restriction, but they cannot be transferred to Comal and Hays County, New Braunfels, and San Marcos because of the springs that are located there. So water rights in Bexar County can't be moved to Comal County. As a consequence, the value of Bexar County, Medina County, Uvalde County, Edwards rights in the market is about a third of the value of that same water right authorized in Comal or Hays County. So, having mentioned that, I want to talk about how much is your water worth. That's that's a challenge. There are a ton of variables that affect the value of water. I want to kind of run through a few of them. One of them is familiar to you, of course, and that's location. Um, a water right with everything you'd want in a water right that's located 100 miles from any demand is substantially devalued by the cost of actually moving that water from where it is to where it needs to be. And that's the other thing to keep in mind. We have infrastructure to move oil and gas throughout the state from where it's produced to where it's needed or going to be refined. Texas lacks a water infrastructure that is readily usable to move water from where it is to where it needs to be. So that's just one factor that substantially affects the value of a water right. I represent a client in Comal County, for instance, that has 8 wells that are capable of producing a ton of water and are authorized under the groundwater district rules to produce that quantity of water. Those water rights are being, let's hope, sold in the very near future for a price that is substantial. Let me just say something like $10,000 per acre foot for each permitted acre foot of water right in Comal County. That same water right in East Texas would be worth 1/100th of that because of the plentiful nature of water. There's no limit on production, that sort of thing. So, you know, when you talk about what water is worth, you need to talk about the nature of the transaction. The regulatory overlay is a factor that influences value. What I call the difficulty of getting permission is a factor. Water quality is a huge component of the value of water. You know, clean, drinkable, potable water that doesn't require treatment has substantially greater value, as you can imagine, than salty water. The other factors are sustainable production. A water right has greater value if it's sustainable over a substantial period of time. If the authorization or the use will diminish the production ability over time, that diminishes the value. So understand that it's a multivariable equation. I'm asked all the time by clients, you know, how much is my water worth? Well, in order to answer that question, I have to look through all those variables, including the potential demand for that water, to come to some kind of idea of what the value might be. And then the nature of the transaction matters. If it's a permanent sale, obviously values are substantially different. If it's a sale of the water on an annual basis, you're looking at the equivalent of a lease. The lease prices vary substantially, again, based upon all those factors. But let me give you some frames of reference. That's probably the better way to address this value question. I mentioned the water rights in Comal County selling for $10,000 an acre foot. Edwards Aquifer rights in the Edwards Aquifer in Comal and Hayes County sell for about $15,000 per acre foot. In Bexar County, it's more like $5,000 an acre foot. The permanent right to sell water or produce water can have a value anywhere from, again, depending on those variables, let's just say $1,000 an acre foot to substantially higher. I've seen water rights sold for way more than $10,000 an acre foot. in in a situation where demand is adjacent and the water is sustainable and of high quality. So understand that all of those things matter. Lease prices for both surface and groundwater rights generally range in the $200 to $400 per acre foot range. So if your landowner wants to lease their groundwater rights or their surface water rights, that should be kind of a bracket for your assessment of what that might mean in terms of value. Again, surface water rights on a permanent basis, an absolute sale of that water right. I've done transactions for as little as $1,000 an acre foot authorization to divert, up to, again, way over $10,000 per acre foot, again, depending upon those variables. So, I jokingly say that water value is such a multivariable equation that it can range from 10 cents a thousand to what I like to say $2 million a thousand. If you buy water in a bottle at a convenience store, you're paying about $2 million an acre foot for that water. Obviously, the value is in the quality, the assurance, the ease, the lack of regulatory overlay, et cetera. But I'll conclude by saying the bottom line is that water values are difficult to assess. It's funny, y'all rely on real estate appraisers on a regular basis. And they, of course, include in their analysis the associated rights of the property, oil and gas and water. But there are there are a few who claim to have expertise in valuing water, but it's not like you can go out and hire an appraiser. So with that, I'm available for questions. I've covered a lot of ground here.
You can. I'm like, we have to have you back. This may be a series, so to speak. Wealth of knowledge. My mind is blown. Very excited. We'd love to have you back, maybe to dive into more specific topics, because it's such a mass topic and resource for our clients. Just like we dive into mineral rights and things like that. And I love what you said. It's very hard. There isn't a water value appraiser, but we do know that water has value. Live water properties cost more than properties that don't have any live water source. And then you have the surface water versus groundwater. And so yes, amazing, and very thankful to have you. I do want to drop in a few links to the chat. Something you brought up, which I thought was a good learning tool, is about the 1 acre foot. So one of the links you recommended, the Texas Water Development Board, has a really cool graph on how to explain the acre foot, the 1 acre foot of water, which I love, because it's, the more you know, the more you grow, and the fact that we can educate our clients on what they're purchasing and that value. Also, I wanted to drop in everyone that's listening. I know we had a lot of questions, and I know we covered a lot of information. So I'm going to drop the links. All the relevant links that Russ had talked about today are going to be in the chat for you to view publicly. Also, this podcast is recorded. You can find it on our YouTube channels. I have my own personal channel, Lindsey Hollin, as well as our Texas EXP real estate agents. We also have our own channel as well. I provide more in-depth information about farm and ranch on a personal level in my experience. So wanted to let you guys have the opportunity. We do get a lot of people that are like, hey, I want to watch that again. What did he say? Because it is a lot of information, and it's all very new information, and it's constantly changing. Obviously laws and rules are definitely changing in that way. Also, to our viewers, if you would like to maybe book a one-on-one with me or reach out to me directly, you can schedule a meeting time. I put my calendar request link in the chat as well. So please feel free to book a one-on-one with me. And as I said before, you can reach out to me or Russ directly. I'm going to drop his information. Actually, I just put it in one of the links. So I dropped the link to the law firm and his private bio there, and it has his email address, his phone number, all those connecting values there for you too. So Russ, thank you so much for coming, and I need to get with you. I want you back. This was awesome. I couldn't have asked for a better podcast on a topic that is so valuable to us and our customers.
Well, thank you very much for having me, and I'm available anytime. Reach out. The best time to talk to a lawyer is before you hire them.
That's another topic I wanted to divulge, because we work with a farm and ranch attorney out of Uvalde, and we've been kind of teaching agents the best practices of with connecting with an attorney. And I know it's scary. I think there's a stigma with y'all, like the dentist. It's we think it's scary, but actually you're on our side. You're here to help our clients make a sound decision. So yeah, I would like to in our next podcast, let's tune into best practices of introducing your attorney and things that you need to, profile your clients to get them in touch with that legal counsel. So awesome. No, I'm so glad you said that. Yes. I'll call you first.
Yeah, my pleasure. And let me say, to the extent you're going to rely on the information, sadly, I may have to charge you. But
you know what? You get what you pay for.
But understand that general questions are easily answered and free. So reach out if you have a general question. I can certainly be helpful in wading through, pardon the pun, the water issues that might arise in your real estate dealings.
Because they can get muddy, can't they?
Indeed. Again, pun.
I love it. Thank you so much, Russ. It was great to have you. We can't wait to have you back.
Thank you for having me.